I'm not a businessman. I'm a businessman. No, actually, you're not. We're going to talk about corporate and business entity formation. A bit about myself. So I'm a corporate attorney or a business attorney. I have a practice here in the East Bay. My background is in finance and accounting, and I do business law, I do entertainment law, and I do IP law. So as I said, we're going to talk about business entity formation, business entity restructuring, and business entity governance, essentially how you're going to run your business once you get it started. So when people ask me what kind of business should I form, I typically give them 4 things to consider. And we'll get to those in a minute. And for the purpose of this talk, we're going to talk about sole proprietorships, general partnerships, limited liability companies or LLCs, C corporations, and S corporations. So where do I start? So I want you guys to just imagine that you're a talented young artist who's going to change the world. People don't know it yet, but you're going to have an impact that is global in scale. And so you have to figure out how to translate your talent into something you can make into a commodity and ultimately protect and market. And this is a young Jay-Z, if you don't recognize that photo. So he's come a long way. And so these are some of the companies that he went on to either found or have a controlling interest in. So as I said, 4 things to consider. You want to consider the projected size of your business. Where do you see yourself being in the near and not so near future in terms of the scale? You want to think about your sources of funding. Are you going to fund it yourself? Are you going to seek investors? You want to think about your liability. If something goes wrong and you get sued, what is your personal exposure going to be? And probably the most important, you want to think about the tax implications. So we are going to talk about taxes a little bit. So I'm going to start with sole proprietorships. So a sole proprietorship is a small business that is typically founded, funded, owned, and operated by a single person. So this is not a distinct business entity. This is a person operating a business under their own capacity. A sole prop can be formed in California without the approval of the California Secretary of State. What is the liability, the owner liability for a sole prop? So the owner of a sole prop is personally liable for 100% of the debts that are incurred by their business. If something happens, an operator of a sole prop is involved in a lawsuit, they're personally on the hook for that liability. So sole props are very easy to start. We could all start a sole prop at this table if we wanted to, theoretically, okay? But there are a few things that I always advise my clients to do prior to starting a sole proprietorship. So one is a fictitious business name statement. So if you're gonna conduct a business under any name other than your own legal name, you'll wanna file a fictitious business name statement in your county of your principal place of business. So if you operate in Oakland, for instance, you will file your FBM with Alameda County. Once you file that statement, you're going to publish notice of that in a local paper. And these typically last for 5 years before you have to renew them. The second thing that you need to do is obtain a business license. So this is not just a good idea. So in Berkeley, for example, it's unlawful to conduct business without a business license from the city of Berkeley. They are required by law. You're going to figure out which business license you need to obtain based on your location. Sometimes it's going to be from the city. Sometimes it can be from a county. The tax implications. So in most cases, the owner of a sole proprietorship does not have to file a separate federal tax return. So rather, you're going to report the profit and losses of this business by filing Schedule C of Tax Form 1040. And just to interject, we're going to talk about taxes. None of this should be construed as tax advice or legal advice. This is for informational purposes only. But I do have the goal of really getting you familiar with the thought process and the things you need to consider, so that when you encounter these issues, you won't think that's beyond your capacity to address. So when is Schedule C of 1040 applicable? It's applicable when you're reporting the income or loss from a business that is operated as a sole prop. People then ask, well, do I really have a business? I have a side hustle. I have a side gig. So per the IRS, you have a business if the primary purpose for engaging in the activity is for income or profit, and you're involved in that activity with continuity or regularity. It's not a hobby. And this is verbiage that is actually directly from the IRS. So it's subjective, but that's the test, and that's what we have to go with under the law. The federal tax implications of a sole prop. So the owner of a sole prop may also be required to pay income tax in revenue that is derived from self-employment. Okay, so depending on various factors, you may be required to estimate these taxes in advance and pay them in 4 installments made throughout the year. This is IRS Form 1040-ES, and it's literally a voucher where you estimate your taxes, you divide by 4, and you submit them periodically throughout the year to the IRS. Again, this is not a suggestion, it is mandatory under law. So really quick, we'll talk about this. I don't know if we'll go through all this in detail, but when is 1040 ES applicable? This is, I hope, is very practical. So in most cases, and this is from the IRS, if you expect to owe at least $1,000 in taxes for 2019 after subtracting tax withholdings and refundable credits. So tax withholdings are what you claim on your W-4. Refundable credits would be a credit that you get for having children, for example. So $1,000 in taxes after withholdings and credits, and you expect your withholding and credits to be less than the smaller of either 90% of the tax to be reflected on your 2019 federal return or 100% of the tax shown on your 2018 return. And this would be for a period of 12 months. So here's an example. I personally don't think this is really straightforward, so I don't want to go into it, but we'll kind of just breeze over it really quick. So let's say you owe $2,000 in taxes for 2018. You had a very good year. Business was better. You expect to owe a little bit more for 2019, let's say $3,000, all right? So your withholdings and your tax credits for 2019 equal $1,000. You now expect to owe $2,000 after withholding and credits. So you expect to owe $3,000, credits and withholdings of $1,000. 3 minus 1 equals 2, okay? So you then ask, are my withholdings and credits of $1,000 less than the smaller of 90% of my 2019 tax of $2,000? 90% of that $2,000 is $1,800, or is it less than 100% of the tax on my 2018 return, which was $2,000? So withholding and credits of $1,000 are less than $1,800 or $2,000, of course. So yes, 1040 ES may be applicable. You don't have to know this, but this is the thought process that you should be going through when you're making these decisions. And just a general thing, let me say just high level, there are tons of people out there that just love doing this for a living. Don't be afraid to approach them, make friends with them. You need to have a tax person, you need to have a tax professional, okay? But you should also have a working knowledge of what they're doing for you. So that's what this is meant to explain. All right, so a summary of sole props. Easy to create, they're fast. You have total control because it's just you. And taxation is fairly simple because you're not filing a separate return. Drawbacks, they're not appropriate if your goal is to secure investor funding because you can't really invest in a sole prop. You can't buy equity in a sole prop. I think taxation may be a drawback as well because you have to be on top of your taxes. And you have to understand how much you owe. In some cases, you may have to estimate that and pay in advance. But the biggest drawback that I see is personal liability. If something goes wrong with the sole prop, the owner is 100% personally liable for the debts that are incurred. So general partnerships. So we now see Mr. Carter, he's growing up a little bit here, and he has some friends with him. We'll talk about general partnerships, size and funding. So a general partnership is an agreement between two or more individuals to co-own and operate a business for profit. So contrary to popular belief, you do not need the permission of the Secretary of State to form a general partnership. A little bit of trivia. Does anyone know the name of Jay-Z's first album? So his first album was called Reasonable Doubt. It was recorded in 1995. Now, one of his first businesses, the record company, was incorporated in 96. So what does that tell us? So the record was funded and recorded in 95, and it was likely a general partnership. This was an informal agreement amongst a few people to form business, and that's what they did. And they later formalized that agreement by forming an LLC. So you kind of get a sense of the trajectory of how these businesses can progress from a sole prop to a general partnership to ultimately an LLC or corporation. So owner liability for a general partnership, each general partner is liable for 100% of the debts that are incurred by the business. If your partner goes out and incurs a debt that's related to your business, not only is that specific partner liable, but all general partners will be liable. So it's called joint and several liability. So you may have 3 people who could potentially be at fault. You sue all 3. So you collect a judgment against one person for the full amount. It's then up to those remaining 2 people to allocate how that debt is really assigned, but each will be liable. So prior to opening shop for a general partnership, a few things you want to do. You want to have a partnership agreement. So these are not required by law, but for a partnership, you have to have something that formalizes it in terms of who's responsible for what. How is the money going to be allocated if and when the company becomes profitable? You want to make sure that it's clear, that's lasting, and that it's legally binding. Okay, and you also want to do a statement of partnership authority. So this is a document that you file with the Secretary of State. It's not required, but what this essentially does is it says this partner is authorized to transfer real property on behalf of the partnership. So if your partnership is in real estate, this is something you absolutely want to have. If not, it may not be applicable to you, but I would be leery of conducting business with any general partnership that did not have one of these documents filed with the Secretary of State, because it's a clear indication that it's really not a formal partnership, and that if something went awry, it may be more difficult than it should be in order to ascertain who was at fault. The tax implications of a general partnership, these are kind of cool because general partnerships are not taxed directly. They have what is called pass-through taxation. So the profit and losses of the general partnership pass through the entity itself onto the partners. The partners then report these profit and losses on their individual tax returns. For informational purposes, the form that they file with the IRS is called Form 1065. That's for the partnership itself. For the partners, they file Schedule K1 of Form 1065. And this basically says if the partnership earned X amount, this amount is allocated to partner number one, this amount is allocated to partner number two, and so on. The percentages reflected on Schedule K1 of Form 1065 need to align with the partnership agreement. If the partnership agreement says this is how the revenue is going to be distributed amongst the partners, that needs to align with what you actually report to the government. The benefits, they're easy to create. You have shared expenses and labor, and you have pass-through taxation. The drawbacks, they really have to be formalized in order to be effective. And you see, again, partnerships being later transitioned into LLCs and corporations. Another drawback is you have personal liability for the action of other partners. So you really have to be careful about who you align yourself with in a general partnership. And then another one that I see quite often is conflicted leadership or governance, because when you have a partnership that is not formalized in the partnership agreement, there's really no clear understanding as to who is responsible for what, not only in terms of liability, but in terms of running the business on a day-to-day basis. So we're going to talk about LLCs next. And so this is a clothing company that's in Oakland. This was founded by an artist from Oakland who called himself Mr. Fab. He's a great artist. He's been doing it for a long time. He's been very successful across many media platforms. He's a published author. He has a long-standing music career, and he has this clothing brand which he established in 2017, which has done really well. This is an LLC, so this is a good example and one that will kind of go with here. So what is an LLC? A bit of history first. So LLCs were first made legal in California in '96, and this was pursuant to the Beverly-Kalea Limited Liability Company Act. This act was replaced in 2014 by the California Revised Uniform LLC Act, and this is codified here. The purpose of enacting Title 2.6 was to replace and better align California LLC law with that of the other 50 states. There's this governing document which is called the Uniform LLC Act. It's a generally accepted guideline as to how LLC should be run, and so Title 2.6 generally aligns with that. So the size, you have a smaller group of investors. To form it, you're going to file your articles of organization, statement of information, your operating agreement, and you're going to create your stock certificates. They're also referred to as certificates of membership. Funding, again, you can invest in an LLC. That's a big plus. Liability. So when an LLC is created and operated properly, you have limited liability protections, meaning that the owners are liable, they're not personally liable for the debts of the LLC past the extent of their personal investment in the company. And that's probably the main plus. So for federal tax implications, they're great because they offer great flexibility. If you're a single member LLC, you can opt to be treated like a sole proprietorship for federal tax purposes. If you're a multiple member LLC, you can elect to be treated like a partnership for federal tax purposes. And you can also choose to be taxed directly like a corporation for federal tax purposes. This is IRS Form 8832. It's a form where you essentially say, this is how I elect to be treated for tax purposes for my LLC. But why is this important? Why is the tax flexibility important? Because we have different tax brackets, of course. Okay, a corporation is taxed at about 21%, and this is down from about 39% from a few years ago. You have to essentially weigh what is your personal tax liability versus what the corporate tax liability is. If you have a business where you plan on expanding and you want to retain earnings from the prior year in order to fund that growth, then if you have an LLC, you can elect for that corporate tax treatment. So that's a big plus of forming an LLC. You can have pass-through taxation as well as direct corporate taxation. And then really quick, for state tax purposes, the tax liability for an LLC is a minimum of $800 per year. It's an annual tax. You pay it every year, irrespective of when you actually form the LLC. So benefits, multiple tax elections. You can also have multiple classes of stock. And I'll touch on this really quick. So every share of stock comes with certain privileges and rights. For an LLC, you can create different classes of stocks. You can say, I have Class A. Class A stocks entitles me to have certain voting rights. So for Uber's a great example because the founders of Uber, or the founder rather, he made sure that the stock that he retained had disproportionate voting rights for his seat on the board of directors. So let's say, if he went out, he got funding for Uber and he issued shares of stocks. He may issue a share of stock that only gave 1 vote per share or no votes per share, while his specific class of stock retained 10 votes per share. With an LLC, you can do that. So the drawbacks, this is not suitable for banks or for licensed professional services. And the key takeaway for LLCs that I always stress to my clients is they require proper governance in order to have limited liability. It's not plug and play. You don't start an LLC and then automatically have limited liability. You have to create it and operate it as a business. This is Jay-Z. We talked about Uber a little bit. He's one of the investors. He was one of the investors in Uber back in 2015. So I'm going to talk very quickly about the difference between C Corps and S Corps. So when you hear the term C Corp, this is not a specific type of corporation. The C refers to the subchapter of the Internal Revenue Code, which governs taxation for these companies. So the C is really just a tax election status. One person can be the founder of a C Corp and they can ultimately be owned by countless people. You can have multiple classes of stock, and these are suitable for IPOs and public trading. C Corps have what is known as double taxation. The income that is generated by the corporation is taxed when it is earned by the corporation. If it is then distributed to the shareholders of the corporation, it is then taxed at that shareholder's individual tax rate. Okay, so if you have a derivative, it's going to be taxed when the shareholder actually receives it. This is IRS Form 1120. For state tax implications, the annual tax for C Corp is $800 or 8.84% of the corporation's net income. C Corps are good if you're going to retain earnings to fund future growth. For liability, again, you have limited liability protection when it's operated correctly. Drawbacks, possible double taxation, and they require proper governance. This is where an attorney's help is really, really helpful. S Corps. Cliff Bar is an S Corp. They're based in Emeryville. Very, very successful company worldwide, but they're S Corp. So an S Corp is just like a C Corp, but the tax election treatment is different. With an S Corp, you have that pass-through taxation. So instead of the entity being taxed itself, all the income flows through the entity and is taxed at the S Corp member's personal taxation level. And that is how Cliff Bar is run. So this is subchapter S of that code we just spoke about. Funding. So you can create and sell stock, but there are some limitations for an S Corp. You cannot have more than 100 shareholders. So these are the smaller corporations. Cliff Bar will most likely never be a public company because that's just not what they want to do. They don't want to be, Nature's Best or Quaker or Pepsi. And you can only have one class of stock. So you can't have that disproportionate voting rights, for instance, that we just talked about. So we talked about the pass-through taxation. And so all shareholders these are tax treatments. You can change them easily, but if you're gonna go this route, all shareholders of the corporation must assent to that tax election status when it's made. Again, for the state tax implications, $800. To summarize here, the drawbacks, only that one class of stock is allowed. Shareholders are capped at 100. So restructuring, this is all you really need to know. All these entities can be either dissolved or merged with each other. Your attorney can help you with this. All right, we're gonna end with this, business governance. Jay-Z, one of his best lines, he says, I'm not a businessman, I'm a businessman. So clever, so witty, okay? But as an attorney, it scares me to death because no, actually you're not. You are a shareholder in a distinct corporate entity and you have to govern yourself as such, especially when it comes to ensuring limited liability. So it has to exist. We're going to talk about LLCs here for a minute again. It has to exist and operate as a separate, distinct entity in order to provide the owners with limited liability. There is this term called the alter ego doctrine. So this is common law, but it's also codified in California state law. And here's the citation. Here's what it says. It says, a court can disregard the legal fiction of an entity's separate existence and hold the shareholders personally liable for the corporation's debt if it would be inequitable not to do so. So you can't form an LLC and go out and operate it, incur debt, and then say, well, you know what, I'm an LLC, so my personal assets will not be subject to this lawsuit. That's not what it's designed to do. There has to be a clear distinction. And this is when governance comes into play. Talk to an attorney. Make sure you understand this and make sure you're following it, because If you go through all the steps to form a corporation or an LLC and you don't follow these steps, you're really doing it in vain. So how do you prove that? Commingling of assets. An LLC, for example, needs to have a separate bank account, a separate mailing address. If you're an artist and you're operating a business and you sell a painting, who is that check made out to? Is it made out to you, the individual, or is it made out to your company? Okay. It has to be made out to the entity itself. You can't commingle assets. Okay, and undercapitalization is another thing that the courts will key in on. So a company should be founded and financed with funds that enable it to begin operation and achieve economic viability. This is spelled out in the bylaws of a corporation or the operating agreement of an LLC. It's called a cap table. It says this is how much this company was started with, and this is how it was capitalized. If a company is not started with enough capital up front to achieve economic viability during a specific period, then it's a red flag that it's really operating as an alter ego for a person. If it's founded with $10,000 and then it goes out and incurs debts that are, say, $100,000, gets sued for it, and then they wave that LLC flag, the court will look at these. They'll say, well, how did you plan on paying your debts for the period where the company was ramping up to be economically viable on its own? So you want to make sure that you talk to an attorney about these things. And these are all spelled out in your operating agreement, your corporate bylaws. You want to have a break-even analysis. You want to have proper accounting. And you want to have record keeping. These are all very, very, very important.